Welcome to On the Ballot, Ballotpedia, where we connect people to politics by providing neutral, nonpartisan, and reliable information on our government, how it works, and where it's headed. I'm Jeff Pallet, and thanks for being with us. Today I'm joined by Dr. Adam Feldman, a scholar on the Supreme Court who runs the Empirical SCOTUS blog. Adam's analysis and research has appeared in and been sourced by dozens of publications over the last several years, including Ballotpedia's, of course. And he's here to help us break down the recent term and what he's looking out for in the 2024 election and next year's term, which starts up in just a few months in October. Adam, good to see you, and thanks for coming on the show today.
Appreciate you having me on.
So first, just tell our listeners and viewers a little bit about your site, Empirical SCOTUS. What do you do over there?
So I'm interested in statistics as they relate to law, and this is an area that is there's not a lot of people that work in this terrain, and so I found a little niche where I could talk about things that are data backed, relating to the Supreme Court in particular, but in courts generally as well. And so when people are looking and thinking about how frequently the court rules in one direction or how frequently a justice is in the majority, I can actually speak to those using numbers. And I think that helps confirm or reject different hypotheses that people have about these things.
Yeah. Why do you think that it suddenly, you'd think that with like SCOTUS, there'd be a high volume of data and interest out there, but you're right. I mean, we noticed kind of the same thing over the years, that it just seems like there is a little bit of information scarcity. So we've been so grateful to find your resource and use it and share that with our audience. But why do you think that gap existed in the first place?
I think it's in one of those areas that is between political science and law, where political scientists are more interested in longer term studies where they can have a larger sample, and law is generally qualitatively based. So it's looking at doctrine and looking at how precedents have evolved over time. But there hasn't really been much work looking at data as it relates to the current Supreme Court. I think that just has to do with it not being directly in the kind of areas that are looked at by legal scholars or political scientists. So I saw this as an area where, given my background in both law and statistics, I could jump in and kind of fill the void.
Yeah. And so, speaking of your background, then law and statistics is such an interesting combination. How did you decide to go down those two sort of parallel, but now you've turned it into sort of perpendicular paths?
Yeah. So I'm a lawyer by trade. I practiced law for several years, but I've also been very interested in statistics and analytics from days even before I went into legal practice. And the more I read about it, the more I saw this as a field that was evolving, and that I could really be, hopefully at that point, at the forefront of shaping. And so after I practiced law for a little while and I saw this interest developing, I went back to school, got a PhD focusing on statistics and quantitative studies as they relate to law. And since then I've been applying both areas of study to understanding the Supreme Court and courts more generally.
Yeah. Well, certainly a niche area. So let's dive into some of those statistics. So the most recent term saw justice decide 62 cases. Now, from what we have seen of the numbers, between 2007 and 2022, over that 15-year period, SCOTUS averaged about 74 cases per term. So why the reduction in caseload this year? What does that tell us?
So I think we can actually start back further. So the first, in modern Supreme Court terms, the first big drop in caseload was right after 1988, when Congress gave the Supreme Court pretty much full discretionary ability. So the Supreme Court got to choose just about every case it heard. And when it stopped having mandatory appeals, for the most part, the number dropped pretty precipitously, almost, in half over about a decade. So we're talking about 150 cases, maybe, to about 75. And that's that area that you were mentioning that existed, in that period when John Roberts took over as Chief Justice. The next big dip was really, it kind of started moving slowly down from there. But during COVID, there was another big dip, and that relates to the events at the point in time and the difficulty in having oral arguments remotely. And the Supreme Court is pretty path dependent, which means that once they go down a road, it's hard for them to go back. And since they dipped in the cases related to COVID, or during the time of COVID, where it went to about 60, since about 2020, it's hovered around that point.
They got used to that caseload, I guess. We all understand what that's like when you get used to a certain eating habit or anything else. But let's go back a second. Wait, so you're saying that there used to be a mandatory case review requirement. What was that? What did that look like? I imagine most of our viewers and listeners don't really know what that means. So what was that, and when did it get changed?
So the mandatory appeals made up most of the Supreme Court's docket for the first 100 and some years. There were very few things that the Supreme Court was actually taking on writ of cert, which is the discretionary petition that's filed when somebody wants the Supreme Court to hear a case. So if you look back early in the 20th century, there were a ton of tax cases, especially around the Great Depression. Those were all coming on mandatory appeal, and those filled the docket. You'd have 200 arguments in a term, and that's compared to around 60 today. So you can think of, we're cut in more than a third of what it used to be. And 1925 was the first time the Supreme Court or that Congress enacted legislation, really putting discretionary appeals at the forefront. And so 1925 and then 1988 were the two big shifts that allowed the Supreme Court to choose most of the cases that it hears. And so this has been a transition over time. And move from almost all mandatory appeals to almost all discretionary appeals for the Supreme Court now.
And what does mandatory appeal, what does that mean? What does that look like? What's an example of a case where the Supreme Court is required to hear something?
Well, right now, it relates to a small number of civil rights cases that are under a specific statute. But in the past, it had to do with relationships to various laws that the Supreme Court was needed to hear based on Congress's legislation. And so the Supreme Court was kind of hamstrung in terms of the cases they could take. And one difference we see is the importance of cases. So these civil rights, civil liberties cases that affect millions of people they didn't really exist in a large sample of cases when the Supreme Court had to hear a high volume of cases. And now that that volume has come down, we see many more cases where there's public interest, where the news is documenting what's going on. And a lot of that has to do with the Supreme Court being able to choose specifically the docket that it has.
Okay, so typically and historically, mandatory appeal was, when a certain kind of case came along or if two courts disagreed by some sort of rule within our rule of law in the country, it just landed on their docket and was like an assignment from your teacher.
Yeah,
you just had to do it.
It even goes back to Marbury versus Madison when there was a writ of mandamus that the Supreme Court was looking at whether they could force somebody to be on a federal court. So we're talking about going back to the 1790s, right? And 1803 for Marbury versus Madison. So there were a bunch of different writs, mandamus, appeal, prohibition, several more than that. And these are all different types of mandatory appeals that the Supreme Court would hear. And so the shape of the way cases come to the Supreme Court has evolved greatly over the years.
Yeah. And, now the volume of cases that the Supreme Court considers every year is enormous. I don't know how most people realize that. I think it's like 4,000, 5,000, 6,000, 7,000 cases are filed. Is that new, or has it always been that way? Or has the 1988 change that? And, it used to be that, 40 cases would be theoretically lofted and thrown at the Supreme Court, hoping they would say yes. And now everybody wants to get their case before SCOTUS.
Yeah. I mean, the expectation for a long period of time was that cases were going to be forced on the Supreme Court, and people had little agency in their ability to say, we want the Supreme Court to hear such and such a case. And we see these jumps in around 1925 and around 1988, where the number just goes up significantly in terms of the number of petitions that are filed before the Supreme Court. So it's really in the last several decades that we see the numbers from 7 to really 9,000 cases filed before the Supreme Court each term. Before that, the numbers were much lower, and that just has to do with people, the public's view of the ability to get cases before the Supreme Court, which, actually, when we look at the numbers, is not that likely. But when people feel the Supreme Court has the ability to hear their case, what we've seen is they're going to file anyway. And there's actually, just in terms of the numbers and the big jump, a lot of this has to do with the Supreme Court taking IFP petitions. That's in forma pauperis, which is essentially Latin for without fees. So when this became a common practice, you have people that are in prison that don't have the funds to file a petition, filing if they have any type of argument that they want to bring to the Supreme Court. So that's really when when that was allowed, we see the exponential jump in the number of petitions.
Yeah, it's sort of like we see this when Ballotpedia covers elections, when it's essentially no cost to run for office or very low, you see more candidates declaring. The most sort of notable example of that is with California's gubernatorial recalls. It's very inexpensive to get on the ballot, which essentially amounts to free marketing and advertising, and many, many candidates run in that case. I'm curious, some of the landmark cases then, Brown v. Board or, Casey, any of the sort of big landmark case people know about, were those likely to have been mandatory appeal, or were some of those predominantly writ over the years?
So early on, these were, like Brown was on appeal. These, were traditionally cases on appeal. So it isn't really until we get into more of the modern era, the 80s, 90s forward, that we have many more of these coming on petition for writ of cert. So like a Obergefell type case, that's
right.
A modern landmark decision where it was on writ of cert. But a lot of the historic ones were not.
It almost makes you think that, there hasn't been enough written, or at least not that I've seen, maybe you've come across it, where people may not realize that the reason why so many SCOTUS cases are contentious or, very political essentially now today are because of the change to writ in 1988, which caused SCOTUS to essentially become a tool that's part of the political activism playbook. And pre-1988 would not have been that. You would have to cross your fingers and hope that your case reached the court.
Right.
But for most political strategists, that would not have been a good calculus of strategy, not worthy investment. Whereas today, both sides of the aisle they are essentially using the Supreme Court as a political tool. I don't know if there's been enough written about that. I mean, have you come across? I mean, you're certainly aware of it, but is that something that's missing from the sort of general political consumers' awareness?
Absolutely. I mean, it comes in academic doses. So, within political science, there are people that write about this, but, it's not for a general public consumer. So, you need to essentially be in a graduate or a program that looks at public law for this to become a kind of normal written work that you're looking at. So that there isn't a lot out there that the general reader is going to be aware of or have access to.
Well, that's why we're here, right? So, what other cases from this term? There's the big ones are sort of commonly known, but what were some of the more interesting, maybe cases under the radar? Were there any that stood out to you?
No, so there were several big issues that came up, and so the Trump cases were obviously forefront to the public, but the Supreme Court took up guns this term. It took up free speech. It took up abortion-related rights, and these cases were looked at in different ways, I think, than they've been examined in the past. And so, while the Trump cases and the administrative state cases had a lot of coverage, some of these lesser-known cases that relate to these issues didn't become the part of the public spotlight in the same way. So the bump stock agency case, where essentially ruled against the agency, the Bureau of Alcohol, Tobacco, and Firearms, and their regulation of bump stocks. NRA versus Vulo, a First Amendment case relating to the NRA. This is one of several Second Circuit cases that was overturned this past term. The abortion cases didn't get to the substantive issue of abortion, so they received less coverage than they probably would have if they touched on the substantive issues on the merits. So there was a lot going on, both on the surface of what the Supreme Court did this term and a little bit below the radar. But there were a ton of really interesting and important cases that the Supreme Court tackled.
Yeah. And I think it's always so interesting. Now we can dig even further into the numbers. So often the Supreme Court is written about through the lens of which president appointed this judge, what's the political makeup or the leaning ideology of the Supreme Court, and it's so often framed in the 6-3 breakdown.
Yeah.
But we were running our own numbers. Looking at the cases this year, and so of the 62 cases, 21 of them were 6-3 split.
Mm-hmm.
So I think if you ask the average political consumer, they'd say, okay, well, I'm sure that all those 6-3s were the standard 6-3 that's promoted by the, any media coverage of the Supreme Court. But 11 of them were of the sort of classically considered 6-3 split based on, political party of the president who appointed that judge. And 10 of them were some other 6-3 combination. So the judges are, quite willing, if you look at the data through that lens, to work with one another and, come to consensus agreements or non-consensus agreements in different ways. So I'm curious, what do you make of that data and of its sort of widely or not widely known awareness?
Well, I guess I would start with just talking about unanimity, even not only the 6-3 cases, but I think most of the public isn't even aware that traditionally the Supreme Court decides 33%, so about a third of the cases, to 50% of the cases by unanimous vote. So generally, the unanimous decisions are the ones that don't get as much coverage because they don't deal with as contentious issues. But when you look at the coalitions that are formed, the unanimous one tends to be either the most common or the second most common. Now, in terms of 6-3 decisions, we've seen, as you were saying, a bunch of different makeups. And I think that there are 2 points related to this. The first is that in a lot of the cases, the 6-3 ideological split is in ones that were predictable, right? This past term, Loper Bright, the administrative state case, came down along those lines. The Trump versus United States came down along these lines. So the really big fractures that deal with political issues still tend to come down the 6-3 lines with along ideological coalitions as well. But there's a lot of different movers and shakers on the bench that are able to put together coalitions that don't look like we would expect them across pure political ideological lines. So we're seeing concurrences now that probably looked like dissents in the past. One example of that would be in like Trump versus Anderson, where you had a concurrence by the 3 justices on the left, Kagan, Jackson, and Sotomayor, that looked like a dissent, possibly in what would have been a dissent in other years, but came down as concurrences. So you have concurrences now where there's large disagreements on how the outcome is reached, but some agreement on the actual outcome. And I think this leads to some interesting formations of different votes by the justices. So there isn't as much of the discussion about justices aligning together as there is about the differences in views. But I think that the public should be more aware of that there are 2 strong sides to this coin.
Yeah. And we notice something like that a lot with school boards. School boards have governing majorities. Let's say there's 6 or 7 on a school board. There's going to be some kind of a 4-3 governing majority at some point in time. But what ends up happening is almost all of the votes are going to be 7-0 because more often than not, a school board wants to come across as a united front. They want to avoid controversy. So most of the time they're going to vote 7-0. Even if maybe behind the scenes they had a strong disagreement and maybe it was actually a 4-3 or even a 5-2 vote. But oftentimes once the minority in those cases realizes they are going to lose, they'll go ahead and join the majority. We've seen that at the school board level. From your review of historical SCOTUS data, did that used to happen more often, less often? Has that never really happened? Because what you're describing is kind of an example that it sounds like.
Yeah. I mean, I think this trend actually started in federal appeals courts because the smaller the panel that you have, the harder it is to be the lone justice on the side. So we see this kind of similarly within the Supreme Court. If it's an 8-1 vote, I think oftentimes you do get the one vote to join with the majority unless they have a very strong opinion. Thomas tends to be the one with very strong opinions in this vein. So he has the most solo dissents of any of the justices on the Supreme Court. Chief Justice Roberts only has one. He tends to be in the majority. And so we see these different tendencies of the justices. But I think, with Chief Justice Roberts' push, we have coalitions that might not have otherwise formed, but are reaching consensus on some important points and he's able to cobble together majorities that might not otherwise exist. So I think that there are cases where you have justices that would dissent that are kind of pulled into a majority. But we wouldn't know that. That's, part of the issue with the Supreme Court's transparency, for better or for worse, is that we don't know their initial votes on the merits after oral arguments. So anecdotally, history shows that about 10% of votes switch from the point of their initial vote after oral arguments and the final votes on the merits. We only know this because of justices' papers from the past. So Justice Blackmun released papers to the public that had a lot of these notes from conferences. And based on that, we know about that about 10% switching votes. But so that's my guess, is that we have some vote switching. We have Chief Justice Roberts pushing for more unanimity, and the combination leads to probably more justices in the majority than we would otherwise see.
Yeah, it's really interesting. And you wrote a little something recently about Kavanaugh and Roberts. What was it that you were writing about?
So that piece has two main points. One is that Kavanaugh and Roberts are almost always in the majority, and they almost always vote together. So part of what I wanted to pick apart was, do they really agree with each other, or do they both just like to be in the majority?
Yeah, 87% of the time in the last term. So yeah, that's that's the most of the. Well, not the most actually, but that's quite a few. Sorry, keep going.
Yeah, no. So they're very often the majority, very frequently together. And so my goal with this was to try to pick apart, do they they traditionally agree with each other, or do they agree with the majority? And the way I did this was dissect when they disagree with each other to see if there are trends in this. And so, oftentimes that when they have different sides on an issue, it's when one of them will kind of play a swing vote role. So we'll side with the justices on the left, and whether that's in the majority or dissent. When one of them sides one way, generally the other one does not. We don't see this, entirely across all cases. But that is to say that on some big issues they do disagree, but they tend to agree on most issues before them.
Yeah, that's very interesting. And what about reversal rates? This is one that we've looked at for a while. I'm always kind of curious about, the basic premise of how cases get to Supreme Court. They go through this system, and oftentimes Supreme Court is telling an appeals court, no, you are wrong. And some courts have a better record, so to speak, than others. What have you seen when you've studied the reversal rates over the years?
Well, this begins with the idea that the Supreme Court tends to take cases that it wants to reverse. This is taught in kind of legal strategy. This is likely the case because the Supreme Court makes a bigger difference when it reverses something. The Supreme Court can not take a case and essentially affirms what the lower court was doing because there is no court saying that they were wrong. So the idea is if the Supreme Court really wants to make a difference in law, it's going to take things that it finds wrong and reverse them. And we see that about 60 to 66% of the time. The Supreme Court takes any case and reverses it. So if you're, playing roulette, you can generally bet on reverse, and you're going to be, successful more often than you're not. That said, there are different rates for different circuits. And so traditionally, the Ninth Circuit has been looked at as the circuit that is farthest to the left. And since the Supreme Court has had a conservative majority, really, for a long, long time, really since the Warren Court, the tendency is for the Supreme Court to overturn liberal decisions more frequently than it overturns conservative lower court decisions. So the Ninth Circuit has traditionally been reversed the most frequently. Also, because the Ninth Circuit is the biggest circuit in terms of total population, the Supreme Court tends to take the most cases from the Ninth Circuit as well. But that hasn't been the case in more recent years. Some of that might be because Trump made several big conservative picks on the Ninth Circuit, and so it's really not as far to the left as it used to be. But it also has to do with the decision making of other circuits. So a lot of discussion over the last few years has been related to the Fifth Circuit, which has some very conservative judges on the bench, and especially in the last few years has made some pretty strong conservative decisions, several of which were overturned by the Supreme Court. So that has people asking, if the Supreme Court's conservative and the Fifth Circuit has these conservative judges making conservative decisions, why are they being overturned? Last term, for instance, almost 3/4 of the time. And that's almost the most of any circuit. The Second Circuit was overturned a little bit more than the Fifth Circuit, and it had a substantial number of cases. But this was surprising to some people, and I think that there are several reasons why this is the case. Perhaps the Fifth Circuit went even further than the Supreme Court was willing to in cases like the CFPB, the Consumer Finance Protection Bureau case, or Rahimi, the Second Amendment case, which I actually think was a bad decision for the Supreme Court to take because it just had poor facts to decide the issue. But the Supreme Court, took a bunch of cases from the Fifth Circuit last term and overturned most of them. It overturned the Ninth Circuit less frequently. So I think we're seeing somewhat of a sea change in the way that the Supreme Court's making decisions related to the appeals court circuits.
Yeah, that's very interesting. I wonder how much people realize that point that you made about the affirming of cases sort of, subconsciously by not taking a case, and how that counts and factors in. So then let's look ahead to the next term. What are you most interested in with the 24-25 term? What cases should people kind of keep their eye out for?
Well, there are several hot button cases that kind of parallel things that the Supreme Court's looked at in previous terms that I'll be most focused on. So Vanderstock is a case that deals with ghost guns, and it's a Second Amendment case. That's going to push the doctrine even farther past Bruin, which was the last big Second Amendment case that really defined doctrine. And since Rahimi didn't really, the court didn't even engage really in this analysis in that Second Amendment case last term, I expect to see some new doctrine come next year. I think the Skrmetti case, the transgender rights case, is going to get a lot of coverage. I can see this as an area that the Supreme Court will probably jump more into in the coming terms. I mean, it's an issue that the Supreme Court's even looked at over the summer on the shadow docket. It had a transgender-related Title IX case, I believe, that it reviewed and held that against the transgender rights in that case. So we're seeing some of these cases. There are some interesting agency cases, a big one from the EPA, looking at those rules. So there are several big issues on the docket, and I expect to see some things between now and really the beginning of the term related to elections. We're already starting to see that with the case that the Supreme Court looked at from Arizona on the emergency shadow docket. And I expect to see a lot more of these applications that the Supreme Court is deciding in short order, and very possibly some of those really pushing into the coming term that's going to start in October.
Yeah. Like always, it'll be a very interesting term to follow along with. So this is great, very interesting stuff. Thank you, Adam, so much for your time today, and enjoy getting ready for the next term.
Yeah, I'm looking forward to it. Thanks for having me on.
And for our listeners, you can learn more about our election coverage at the link in our show notes. We'll be back next week with another episode. Make sure you subscribe to On the Ballot wherever you listen to podcasts. I'm Jeff Palais, and thanks for listening.